If a newspaper posts an article on its website, readers everywhere can see it. But does that mean that the newspaper is subject to personal jurisdiction in every state where the article is accessed? The court examined that issue in Young v. New Haven Advocate. In late 1999, to alleviate prison overcrowding, Connecticut transferred 500 prisoners to Virginia's Wallens Ridge State Prison. The transfer sparked controversy, and newspapers in Connecticut, including the New Haven Advocate and Hartford Courant, reported on the public debate. The Advocate published an article discussing the harsh conditions at Wallens Ridge and the difficulties of the long-distance transfer for inmates' families in Connecticut. The article also mentioned concerns that Stanley Young, the warden of Wallens Ridge, had Confederate Civil War memorabilia in his office. The Courant published similar articles that expressed concerns about the transfer and conditions at Wallens Ridge. The Courant's articles discussed letters from transferred inmates describing cruelty by prison guards. Young brought a libel action in Virginia federal court against the newspapers, their editors, and the reporters who wrote the articles. Young alleged that the articles implied that he was a racist who encouraged guards to abuse inmates. The newspapers, editors, and reporters moved to dismiss Young's complaint for lack of personal jurisdiction. They argued that the newspapers were local Connecticut papers with very few Virginia subscribers. They didn't have offices in Virginia and didn't derive substantial revenue from Virginia. No newspaper staff had ever traveled to Virginia while writing the articles, and none of the reporters or editors had any other contacts with Virginia. In response, Young claimed that the court had specific personal jurisdiction because the newspapers posted the articles on websites accessible to Virginia residents, knowing that the articles would expose Young to public scorn in Virginia, where he lived and worked. Young also submitted printouts of the newspaper's websites, showing Connecticut-specific news stories, weather reports, and ads. The district court denied the motion to dismiss, ruling that it could exercise personal jurisdiction under Virginia's long-arm statute because the newspaper's internet activities in Connecticut injured Young in Virginia. The Fourth Circuit allowed an interlocutory appeal of the decision.